the resumption of our inquiry today, the 10th of November, 2022.
Recording in progress.
Thank you, Tsepo. Now we know that we connected up there. Just want to welcome all the honorable members of the Section 194 committee here at M46 and on the virtual platform, and recognize the public protector here in Cape Town at M46, together with a legal team led by Advocate Mpofu, that you are here in Cape Town physically and not here in Cape Town virtually. Thank you, you're welcome. Acknowledge evidence leader, Advocate Bauer. We have an apology for Advocate Mayosi, who is not with us today. But also acknowledge the members of the public who are joining us in their various platforms and parliamentary YouTube and 408, members of the media, our entire support team that has been with us in this process. I also want to acknowledge the presence of Mr. Cornelius from the Merwe, who's our witness today. Mr. van der Merwe, please switch on your video and indicate if you can hear us.
Good morning, Chair and members, public protected team. Yes, Chair, I can hear you. Am I audible?
Thank you.
Thank you.
And
I can say thank you.
I had indicated yesterday that today and tomorrow Advocate Mpofu will be doing the cross-examination of Mr. Cornelius from the Merwe. I also got a request. I see there's a mic on when I have not recognized anybody. So I also got a request from Advocate Bauer yesterday, which I deferred, about wanting to put certain matters on record. So I wouldn't want to mess up Advocate Mpofu's cross-examination, and therefore we'll start with that when I come to you, that will be cleared.
Okay.
Or unless you want to talk to me before I go to her. I recognize you.
Thank you very much, Chair. No, I just wanted to say I also have a request, but I think Advocate Bauer came yesterday, so she must take precedence, but I can talk after her.
Okay. Thank you, Advocate Mpofu, for that understanding. Advocate Bauer, I recognize you and hand over to you.
Good morning, Chair. Good morning, everybody. We had and the reason why I've asked for this is to place a context into the evidence that had been led last week that had created quite a bit of consternation. And the second leg of that is to correct errors that we had made in the result of that. So let me start off by dealing with the question of a context. We had during the course of the hearings, we had two requests emanating from the committee. One was the number of reports reviewed and set aside. And before Advocate Mpofu leads his cross-examination with Advocate van der Merwe, I'm going to ask the Chair for a few minutes at the start because there was an aspect of the evidence that I had neglected to lead in respect of that, and I need to indicate that. We had produced a table of the summary of judgments for the entire period, which reflected the case, the outcome, the internal and external legal representatives, and what emanated during the public protector's term and which had been left over from her predecessor. We had also, during the course of the evidence, reflected the timelines of the cases, the number of court appearances, the appeals in the cases dealing with in the motion. It was in the context of these cases and the mandate that we put evidence before the committee of the cost of the cases relevant to the motion. And what we did was, after having had a conversation with the PP's team, we had put up a globular figure of the cost of the ABSA matter, the litigation with the speaker, and I think there was one other that I've forgotten now. And I indicated that I would provide the further information relating to the rest of those cases when Advocate van der Merwe gave evidence, which was then contemplated to be within days. And it was Advocate Mkhwebane had then raised concerns of privacy with us, and I, in providing the figure, had not sought to make any reference to the legal representatives who had rendered those services. He had objected to this evidence on the basis of relevance, and we had pointed out to him that in the context of paragraph 11 of the motion that stated Advocate Mkhwebane had committed misconduct by and or demonstrated incompetence in the performance of her duties by one, failing intentionally or in a grossly negligent manner to manage the internal capacity and resources of management staff, investigators, and outreach officers in the Office of the Public Protector effectively and efficiently, and two, failing intentionally or in a grossly negligent manner to prevent fruitless and wasteful and or unauthorized public expenditure in legal cost. That was the context in which the evidence was being put before the committee. The committee then sought from us a breakdown of these costs as to who rendered the services, the attorney and the advocates. And there was a debate in the committee about how this request was worded. One of the members had used the word benefit, and another had said it should be those who provided the service and not benefited. We understood that what was sought was how, over the period from the start of the PP's tenure, were the funds spent. And in the conduct of this exercise for the 2017 to 2022 period, I then asked the committee, can we report on legal costs from 2 million upwards, aware that if we were to do this for every invoice over the 6-year period, it would be a mammoth task, and then we would not be able to meet what at the time was days within which that evidence was going to be led. At the time, Advocate Mkhwebane's objection was not sustained on the basis of the same principle articulated yesterday, that the expenditure of public funds is not private. I too have been the recipient of fees being put in the public domain through parliamentary process, and so have a number of other advocates. But at the time this request arose, we had already put up the evidence indicating that of the expenditure, the amount of 147 million did not all relate to reviews of reports issued by the Public Protector. It included labour matters that did not relate to review of reports, and when Mr. Chialela gave evidence, the committee had that information provided. We indicated that there were matters that commenced with the previous Public Protector that showed the outcome in those matters were pending and were either not opposed or withdrawn, and there was some legal cost emanating in relation to those. We had pointed out that some of the 147 million, including fees from 2 of the law firms, being fees reflected in the over 2 million category related to cases that emanated from the period of the previous PP. We also reflected that there were costs arising from other civil cases. So it was in this context that last week the evidence leaders sought to meet the request of the committee by putting up some of the legal figures as requested, spent over the 6-year period of the current PP. And we started the evidence by showing what the audited figures reflected over that period globular were. Let me be clear, there was no suggestion on the part of the evidence leaders that there had been looting or thieving by any of the advocates in the evidence put up in relation to the figures. It is regrettable and unfortunate that it was couched in that way when it went out into the public domain. And it would be incorrect based on the evidence that was laid before this committee for such conclusions to be drawn. We had not, in providing the numbers, conducted audits of case files or work done. And it's unfortunate that it is in the context of how this evidence came to be led that it is suggested that the evidence leaders had been off on a frolic of their own when they were doing what the committee was suggesting, or that they sought to cause embarrassment to either the public protector's legal team or to any other legal professionals whose fees were flighted. I reiterate that what was provided was a request to account and reflect transparently on how the 147 million had been expended. And of this, we showed the expenditure of 133 million. There was no targeting of the counsel involved and in the inquiry, that the same counsel that were briefed in some of the matters and received funds for that matters appear in the hearing is as a consequence of how the figures came out of that exercise. There was nothing contrived about it. For further clarification, we sought to do this work by converting the work we had done on globular figures by indicating the following categories. The above 2 million category, and where there were fees marked by advocates and consultants on cases directly in the motion. And in doing so, we were mindful of the allegations made by Advocate Mpofu in his recusal application to the following effect. We stated, and I'm going to put it in context, in spite of the above and despite valid objections based on privacy and relevance having been raised, the chairperson has and continues to allow the wanton display of earnings by professionals who rendered the legal and related services to PPSA. By that stage, this was an objection when we had referred to specific invoices reflecting the employment of Mr. Mkhwebane, we presume, because there had been no other invoices before the committee up until that point. He went on to say that the intention seems to embarrass members of the present legal team, the public protector. In pursuit thereof, inaccurate and misleading figures have been allowed to be bandied about in the public domain. For example, the total figure of 48 million spent over a period of 5 to 6 years in portraying as current expenditure, that being the amount reflected as having been paid to Senego attorneys during the period 2018 to 2022. The evidence leaders have also stated that Senego's attorneys were paid 49 million, which is false. The correct figure is below 40 million, of which only about 10 million less VAT over a period of 5 years was earned by Senego attorneys, and the balance was paid out to a number of senior and junior advocates handling the relevant briefs and depending on the size and duration thereof. As a consequence, and given the instruction, we sought to put up the earnings by the law firms in the over 2 million category and 17 advocates and a consultant that rendered services, and in so doing, ascertaining the veracity of their foregoing. It was not the purpose of the evidence to dig into the earnings per person, but rather to reflect in the context of the evidence that had been led to date and to confirm to the committee what the situation was. When the schedule had been prepared and was flighted, it was made bigger for the committee to be able to read the numbers, and data fell off the virtual screen. As we did not go through the list of each person, it appears that what was not seen were the names of the bottom of the list provided, to including the names, and I'm going to mention it because of certain connotations due to the absence on the list that had been flighted, being the names of the late Advocate Kennedy having been specifically raised with us as a name we were accused of deliberately having omitted, given that he had worked on matters material to the motion, and the counsel that acted in the Sheedy matter, Advocate Smith. But this was not so, as the names were on the list. I raise this because of the accusations of some sort of racism and the inference that the evidence leaders had sought to shield white advocates. It does bear noting that for the period 1 January 2017 to 22, from the invoices provided to us, there was only one white advocate who had earned more than 2 million, and his name was on the list. Whilst the screen is an aid to facilitate the evidence in a hybrid environment, the evidence is the document itself. So let us be clear that based on the document prepared by the evidence leaders, there was no omission on the basis of race from the list, nor did we do this at our own behest. What we did in, and we take responsibility for that, is that some of the figures that provided were not correct, despite our extensive endeavors to provide an easy to understand way of how funds were spent, and to lead that through Advocate van der Merwe, right? And we were not aware that we had made this error up until Saturday, when we were alerted that there were some errors in the figures that had been provided, and that some practitioners were aggrieved that figures were not incorrect in the schedule that had been prepared. And two of those advocates are here today, Advocate Ngwane and Advocate Sikakana. And bearing in mind that we had only provided the high-level amounts and not the schedules of each law firm, to do so in oral evidence would have taken us hours in the one day that we had to provide those evidence. We then revisited these figures, and it confirmed that the version flighted was not correct. We checked all of them again, and Advocate van der Merwe, together with myself over the weekend, did this for purposes of correcting the errors based on the invoices provided. I indicated to Advocate Mpofu that we would place on record the errors that we had found to have been made, and to provide the committee with the reasons for that. That the version flighted had contained those errors. Firstly, our mistake was that certain changes had not made its way into the main document, and we had found that in sharing the document on Dropbox, it had not synced the changes made. And we have endeavored to do that, and we have endeavored to deal with it, and we think we've now sorted out the distortion of that. But apart from that, and we take responsibility for this, we did find that certain errors had arisen in capturing the data from the invoices to the columns in which the different advocates' names were listed. And in doing so, we had attributed fees to the wrong practitioner. In one regard, by way of example, because they're both sitting here, is that an amount that had been earned by Advocate Mpofu was wrongly attributed to Advocate Ngwane in respect of a payment that had been made by Senego attorneys. We had also, and that's one of a few of the errors we had picked up. There were not many, and what we've done is, instead of providing the document we did have, we sought to, and I'll get to that in a moment once Advocate van der Merwe is on there, we sought to take the document that had been flighted and highlight in yellow the changes that we had made, so that the committee could then see the differences between what was there and what we now have. In doing so, we had also overlooked one of the law firms that had rendered services in the ABSA matter at the inception of the brief, being Sef and Yatso attorneys, and hence the earnings from that firm was not provided for. It was not a huge amount at the time, and we had just overlooked it. We did leave out some of the advocates who had rendered services in the 2017-2018 period in the matter of ABSA versus Vrede on the document that was flighted. And particularly given that the accusations of racism, and for the sake of completeness, we then added them to this list. We've marked that in yellow. They are 8 in number who at some point or another in 2017-2018 rendered some legal services in either the ABSA or Vrede matter. Of the 8, 7 are black practitioners. So to the extent that Advocate Mpofu yesterday accused us of targeting black practitioners in the way the evidence was led, I make it clear that of the 8, all 7 were black practitioners. The inclusion does not reflect much, given that the total doesn't make much significant difference to the expenditure of 147, because they are accounted for in largely figures that is to be deducted as well. We have not been involved in an orchestration to come out with any sort of nefarious motive. We endeavored to account to the committee pursuant to an instruction. We do owe an apology, and because we had flighted it publicly, we make this apology publicly to Advocate Ngwane, Advocate Sikakana, and the others whose fees we had indicated to be incorrectly. And I do acknowledge that Advocate Ngwane was instrumental in bringing this to our attention. I must also point out that we still have figures, and Advocate Ngwane and I had an exchange yesterday. My figures as provided on the invoices from the PPSA office still does not accord with the invoices which Advocate Mkhwebane has said. And there are numerous reasons why that is so, not based on any nefarious reasons. Sometimes it's just an arithmetic calculation based on the fees as reflected in the attorney's invoice. And given that the errors were reflected on the screen, it appears that the only way to remedy this is to flight the revised figures devised on the screen again. And Chair, those are what I wish to place on record. And in dealing with those highlighted errors, I would need to do that with Advocate van der Merwe.
Chairperson.
You only have to, you are here, you can raise a hand.
Oh, yes.
Advocate Mpofu.
Yes, thank you, Chair. I'm used to
because
raising.
you've already switched on your mic before you even recognize. So I'll tell you again.
I understand.
So let me pause, Advocate Bauer, Advocate Mpofu.
Thank you, Chair. So sorry, I'm used to raising my hand on the computer now. So, no, Chair, I wanted to raise an objection for what it's worth. That this issue, which is quite serious, should not be treated in this kind of fashion. As I indicated earlier, my colleagues, Advocates Kakane and Advocate Ngalwane, are here, as Advocate Bauer has said, to deal, or rather to request from you, Chairperson, to be given an opportunity to deal with this.
I'm going to ask you to do that proper.
Yes, no, I will.
Whatever you would have indicated earlier would not have been this platform. You would have either whispered to me.
Yes.
So if you have to indicate something, you're going to do it.
No, Chair, I will. Actually, you don't need to say that. That is the something that I had said earlier I was going to raise. I'm now raising.
That was my expectation.
Yes. Now I'm raising it in a different context now, in the context of the objection that I'm making. I'm saying that the Advocates Kakane and Ngalwane SC are here to address this very issue. And I would request you, Chair, that before Advocate Bauer does what she is now proposing, which is to actually repeat the offense that she has apologized for, that we deal with it at the level of giving us or me or them the opportunity to deal with it. And then at that stage, Chair, you can then rule whether it should be done. Because to do it again now, if it turns out that it was wrong the first time, then it means you're going to do it for the second time and then maybe find that it was wrong. That would be just aggravation, unnecessary aggravation. So it's an objection from that point of view, from a practical point of view, Chair. If you rule after you've heard all of us on this issue, at least the victims of the offense, then you will abide by your rule. But we cannot allow it to be done beforehand, before that matter is addressed. Thank you, Chairperson.
Oh, yes.
Sorry, Chair. The reason why I posed the question, Chair, with your leave, as a clarification, right? I'm not adverse to what Advocate Mpofu is suggesting. My last indication was we had been responsible for putting the incorrect figure up on the screen, which had gone out into the public domain. The only way I can see for us to correct that is to put the correct figure in the public domain. If those who we had posed an incorrect figure doesn't want to put that out into the public domain, then they must address the committee on that. What is important for us as evidence leaders to do is to put the correct figures before the committee.
Okay. Now, thank you, Advocate Bauer. I've had both of you. I think I'll hold you back on that. Let me do this. Advocate Mpofu, today and tomorrow is scheduled as cross-examination by the PP legal team. That is the us I know. There's no other us. Because I see you speaking about us and then you point towards the two legal eagles that I've seen here. I don't know through which window they came through, but they're here. And I was hoping that you would do the thing, and I'm going back to you, that you're going to have to do this properly. Is there a request you want him to make, or you are saying they are here to support and listen to your cross-examination? So I would not have introduced them, and it was deliberate not to do that.
No, Chair, thank you. I appreciate that.
Because the other one, just for record, we happen to be in the same space in another institution. So we credit each other in that way, to be mentioned later.
Yes, Chair.
Advocate both.
Yes, Chair. No, we don't want to know where you met in other places.
No, it's not a request on you. I will do it.
Thank you, Chairperson. No, Chair, thank you. No, Chair, I must say I appreciate what you have done. I knew when you did not acknowledge them that you were doing it properly, because there had not been any formal issue. That's why I raised the hand earlier. I didn't anticipate that there's going to be an objection which would be warranted. And maybe, Chair, if you allow me, before I do the right thing, as you say, I just want to point out, I mean, as they say, don't look a gift horse in the mouth. You've already made a ruling in my favor, so I don't have to motivate after that. But
I'm not sure if I've done that yet, but proceed.
Yeah, well, at least for now, you've held it back. Yeah. No, I'm saying, Chair, that once you've made a ruling, I don't need to address it, but just allow me to point out, for the benefit of Advocate Bauer in particular, that yes, she's right about the issue of accuracy and so on. But as it will be clear, at least from me now, I'm speaking for myself, and my team, the serious objections we have on this, and it will also become clear when we do the cross-examination, are not only based on accuracy. Accuracy, if it's inaccurate, that makes it even worse. But it's about the idea of putting up people's names in vain without their having been consulted. So that's why we're objecting. We appreciate the issue of accuracy that she's trying to resolve, but unfortunately, that's not the only issue. Actually, it's a minor issue compared to the real issues here. So that's the issue about the objection. I was just putting it in perspective. Chairperson, and again, you're quite correct that we were talking informally before, so we need to do things on the record. As has already been noted by Advocate Bauer, we have in our presence members of the legal profession, members of the public, whichever way you want to look at it, South African citizens who have visited their parliament today. Advocate Skakane SC, Moses Skakane SC, and Advocate Vianney Ngalwana SC. They are members of the Pan-African Bar Association of South Africa, PABASA, and well-known advocates in South Africa. Some of the group that's called Eminent Counsel. They have asked us to request you, Chairperson, because we're the ones who have the platform to talk, to request you for them to voice their objection, formal objection, to the committee via you, Chairperson, and to the Parliament about the events of last week. I will, as I said, I will address them in
It's not me who's disturbing you.
no,
it is the public.
It's not you, Chairperson.
Yeah.
They will address. I was saying I will address the matter in my capacity as the legal representative of the public protector through cross-examination. I addressed it yesterday partly, so I don't have to address you. Safe to say that we in my personal capacity, at least, I will take whatever steps might be necessary, and so will the public protector. But the two colleagues simply want to request you, Chairperson, to be given the platform with respect to voice those objections, because they are senior members of the profession. There are junior counsel and attorneys who have been affected by this quite adversely. But they are, as I mentioned yesterday, but they, because of their position in the profession, they would not be able to speak for themselves. And if they did, there would be some repercussions either on their careers, worse than what has already happened. But these two are worn out veterans, so nothing can more harm them than, as I indicated yesterday, some of us are just, by now have a battered syndrome on this kind of overt and covert racism. But Chairperson, so that's the request really. It's for the two colleagues to speak for the people they speak for, and for us in a way, in the sense outside of our professional engagement in this committee, just in our capacity as some of the people whose names were flighted there in vain. Thank you, Chairperson.
Thank you.
Sorry, Chair. My understanding is that they have a statement which they want to deliver to you formally, and then if there's any engagement, it can follow. Thank you, sorry, Chair.
Thank you, Advocate Mpofu, for that impromptu request you're making. I think the first thing that I must do, you having said what you've said, is for me as the chair on behalf of this committee first to welcome senior counsels Moses Kakani and senior counsel Vianney Ngalwana for being present here and having introduced them. I deliberately did not do that so that because I didn't know. I was later, if they were here in support, was going to acknowledge them as such, as you would have been supported even by ombudsmen from Kenya and Zambia and so on. I am hearing your request, and I'll try and insulate the two senior counsels from this, because I don't think that from listening to you, it is clear in which vehicle they came here, that you'd have been the driver of that vehicle to bring them here.
No, I was not.
To start with, I'm not asking you to respond.
Oh, apologies, Chair.
So that's the first thing, because you make an important point, but we are running an inquiry. I would have indicated to you yesterday the importance of respecting the time of the witness, which we did yesterday. I do want to remain consistent in that, but also to indicate that as the committee, we would have no problems in listening and hearing any concerns that people will raise with us, especially as it pertains to the work that we're doing, that we have been charged to do. I will have to come back to you, because you should have known this better, and I know you know it, that in this committee, this is day number 33 or so of witnesses, there would have been quite a number of names that would have been raised here as part of this inquiry. Some would be aggrieved by the fact that their names were raised here. And it is our responsibility that we don't close our ears and eyes, so that we must be able to hear them, and we must be able to see them in the issues that they raise, whether it's a discomfort they have. And in fact, it is our intention that, and let me make one practical example. When we dealt with the issue of the recusal of the evidence leader, Advocate Bauer, we would have received a formal correspondence from Barnabas Tolo attorneys who wrote to us, and that's a proper thing to do, who wrote to us to say, in your committee, these issues were raised. I register as BXI. I'm just shortening that. I register our concern and discomfort, and we want clarity, and would have responded to Barnabas Tolo attorneys correctly in that way. And would even be open if at some point he makes a request that I want to address you as a committee. There is no way that this committee of the National Assembly, this tribune of the people, will refuse to hear such. I'm making that point, and I'm sharing that example, Advocate Mpofu, to say that's what would expect. As I sit here, I do not have that registered with the committee to say we've got this difficulty. We have a heavy heart about what comes out of your committee, and would want to raise this. So I think it's important that I put that up front, because we have to do things sustainably. I can't be having rules that apply to this and not apply to the others. That if many that would have their names raised would, they might not have the opportunity that the two legal eagles that I respect had, that they would have come through that door through you, but they would also want to raise certain things. So with that, I want to indicate the following, Advocate Mpofu, in dealing with this, that and the committee can put me around the necklace around this, that I will still request that both senior counsels put their concerns fully in writing, because the concerns they have would be interested as the committee, even when we deliberate on the evidence that has been placed here, to consider those issues. I would urge that they do that formally, they put that in writing. And if there is a further request on their side to say, we're not only putting in writing, we want to make the following points to you, I would encourage them to do that. Now that we find them in the room, I don't know whether you want to stop me, Advocate Mpofu.
No.
Please switch it off.
Sorry, Chair, it's a mistake.
Thank you. Now that we find them in the room, as a chair of the committee. So, as a chair, I'm being hijacked, but I don't see myself in danger by the hijacking. This committee is being hijacked. It might be something that will help the committee, but it is a kind of hijacking. And Advocate Mpofu, you are responsible for that, because I'm going to repeat this point.
Chair, I don't want to interrupt.
Don't interrupt.
How do you know that?
You've just introduced them that they will now. Thank you. So don't deny that. You've just put it on the record. Yeah, you introduced them.
Chair, you're being unfair, but I'll respond later. I don't want to interrupt you.
There's no need for a response for that, Advocate Mpofu. So the point I'm going to ask that it be done, because I respect the time of the witness. There is no way that we would allow an unplanned situation like that and open that door that I will not be able to close for any other who might have been aggrieved and have concerns about that. And I'm saying the committee can beat me on this, but as a chair, I want as courtesy to ask both Senior Counsel Skakane and Senior Counsel Ngalwana. Advocate Mpofu, please switch off the mic.
Oh, okay, Chair, but you've noted me.
I do not appreciate now.
No,
I've asked you several times.
I promise you, Chair, I didn't see it was on. The same as Advocate Power told you the same thing, and you appreciated it then.
Advocate Mpofu, I don't think you need to go there.
No, you're the one who's going there. I'm telling you, I pressed the thing by mistake.
Several times you just pressed the mic for
Yeah,
no
but
reason.
I pressed it by mistake.
Have
Have you ever not done a mistake in your life?
the mistake is accepted.
Thank you.
Please switch it off. Thank you. I was indicating, colleagues, that I think for courtesy, I'm going to ask both Advocate Skakane and Advocate Ngalwana. And I would have indicated that I want to insulate them from the points that I'm making. That having asked them, even after this, to formally put things on record and in detail, that now that they are here, unless you have a problem with that, I do want to ask them in few minutes, collectively 10 minutes maximum, to only register the point with the hope that you will go to follow as I have indicated in writing your concerns, so that even members of this committee have that. So I wouldn't want, even though I find you here, to just say, please leave the room. I think it would be fair that I ask you to register the point on the record, and then you will follow that up and would be amenable as the committee to further listen to that. Members of the committee, would you have a difficulty with that? Honorable Melder?
Thank you, Honourable Chairperson. I think that it's a fair ruling, but I want to ask that you strictly adhere to the time that you have given. We don't want our platform to be hijacked or attempted to be hijacked. We've got a different program for today. Thank you.
Thank you, Honourable Melder. Honourable Zungula?
Chairperson, I think it's a good proposal. Let them register whatever that they need to register. Thank you, Chairperson.
Thank you, Honourable Zungula. Honourable Gondwe? Then Maneli, then I go to...
Chair, my only concern is that we are setting a precedent that tomorrow someone else can show up here and say my name has been bandied around in this inquiry. And, you know, I don't want us to open a door that tomorrow we're going to find difficult to shut. So, yeah, I just wanted to put it out there that let's be careful about the precedent that we're setting. Tomorrow we could have, this is an example, Mr. Mkhwebane, Paul Mkhwebane coming in and saying he also wants to register his concerns about what's been said about him here. So I don't want us to open the floodgates, if I may put it that way, in this regard. So okay. I'll just caution that. Thank you very much.
Thank you, Honourable Gondwe. I will respond to that, as I would have addressed it in my comments. Honourable Maneli?
No, thank you, Chair. I think we agree. Also with the ruling you've made that for the future, this is what would then happen. And I think for me, it's like Honorable Gondwe was reading my mind about precedents. I think the precedents will be the ruling you've made, that for the future, this is what would happen. But you've also recognized that this is a people's parliament, and it will be wrong to just act as though people were not here. So I agree with the ruling. Thank you.
Thank you, Honorable Maneli. As I go to my two senior counsels, just to make the point that even in committees of parliament, we have a particular approach we apply. There would be early warnings for request and all of that. But I had indicated that in anything else we're going to say, the two are insulated. And I repeat that point, so that when they speak, and it goes to this issue of the precedence, Honorable Gondwe, because I would have attended that it's important that as a chair, we allow and hear the senior counsels out. So thank you very much, honorable members, for that. With that, I will respectfully recognize. I don't know which one wants to start, but no senior up.
Chair, please, if you can allow me to speak first, just on some point before they speak.
I will allow you after Advocate Mpofu.
No, it has to be before.
I don't want any responses to what have been said. Thank you, Advocate Mpofu.
Yeah, just
dictator. Senior counsel Moses Kakane. I recognize you, and the platform is yours.
Chair, thank you very much. We would like to thank the committee. We know how important your work is, and we apologize for coming this way. We did so because of the gravity of what Ms. Bauer did. And maybe members of the committee do not understand the gravity of what she did. We thank you for allowing us to do it this way. And we apologize that it looks like a hijack. We had no other way of doing this because the gravity to Black professionals who are junior, who are women, is great. That's why they're not here. Chairperson, our appearance is indeed an extraordinary occurrence, and we will give you a written statement that we have. And for that, as I said, we thank each and every member of this committee and parliament. We know you're tasked with a very important matter, and to the extent that you will be required to make your decision, we are here to correct a distortion that occurred here last week. We appear before you today in order to assure you that we support the call for accountability because it's public funds we are dealing with, but we reject the notion of perpetuating a stereotype against Black people because this parliament was established to vanquish those stereotypes. And Ms. Bauer is at the heart of doing this as a colleague. And he's not doing it for the first time, by the way, if I can tell the committee, not here, elsewhere. We are here, therefore, to alert you that people like Ms. Bauer, our colleague, can abuse a good process like this for purposes that this parliament was not created for. This very unfortunate event, which happened last week, the manner and content of the supposed evidence of the PP's office expenditure on legal fees point to a clear pattern. Chair, we chose today because Mr. van der Merwe, who's the witness, is a man with whom both of us consulted recently. And not once did he alert us that this would happen to us. Chair, consistent with the most common mischief and racist perpetuation of a stereotype against Black professionals, Ms. Bauer knowingly and purposely, in our view, brandished our names and without any context to the public, read out alarming figures of monies we're supposed to have made, almost giving the impression we were looting our system. She knows that counsel in our referral profession submit their fee notes to the instructing attorney for payment for legal fees, for legal services actually rendered. Counsel is not given money by the client. So why did she try to create a direct correlation between the person of the PP and the fees paid out to instructing attorneys to specifically selected counsel? Of what discernible value is it to this committee to know that a black advocate was paid 1 million rand for legal services in 2019 under Mkhwebane, Advocate Mkhwebane, if a white advocate was paid the same amount or more in 2015 under Madonsela? We want to state it categorically that we really reject Ms. Bauer's intended theory to portray black professionals as corrupt. We reject as unprofessional her conduct to use her position in front of this very important place called Parliament to project that the figures that were put up were simply funneled to us by Advocate Mkhwebane. We want to state it that we work under very testing conditions, and our juniors who are not here because they fear for their lives, because they've been told that they are corrupt by their family members. We are here to correct not the figures, but the fact that accountability for public funds could have been done without flighting our names, without telling the public that money was funneled to us. A person we regard as a colleague did what she did last Wednesday, as I said, knowing full well that the public, and indeed some of you, may not be aware that some of her figures are wrong. She has acknowledged that, and that she omitted the important context of the period over which these figures were accrued, even if they are accurate. In focusing on the figures, she omitted to explore the precise nature, the complexity, the importance of the value of the legal services actually rendered, thus perpetuating a stereotype that our services as black professionals are of no value. She's never going to tell you how much she has made sitting here and how much she made in the Muhoro matter, because we must be projected to the public, our people, in a particular way. Ms. Bauer hung us out to dry in an attempt to perpetuate this stereotype. A far more useful comparison for purposes of this process, I venture, would have been the legal fees, if we really want openness, paid to each of the white advocates and white law firms that render services, to all public protectors, regardless of who they are. To simply say the budget for legal fees was lower than is no answer. What fees were actually paid to those white advocates and firms, and what was the nature, value, performance, and complexity of the work they did? This character assassination, in our view, even if it was not her intention, that was what we've been subjected to since her statements, since this was published. What large sums of money has she herself sitting here? And she's not doing it for the first time. In the case of Panabantulu in the High Court, she did the same. So the apology is not accepted for that reason, because it's contrived. Like all stereotypes, Ms. Bauer tried to impute, to nurture the difference between black and white by selecting us in a poisoned context and theory of abuse of state funds that she sought to sell to you. She throws the names of selected black advocates in order to ride on the old racist stereotype that black is corrupt, which we reject. Whether she intended it or not is irrelevant. She did this with the full knowledge that she had outside in the media space fertile ground in the Daily Maverick that now characterizes our fees, not as having been earned for legal services rendered, but as money is having been funneled to us through Advocate Mkhwebane, which is not true. Her theory seeks to use this important process, our process, the parliament of our people. She uses it to perpetuate an old racist stereotypes against Africans. She knew full well that this would be the outcome. She knew full well, she's aware of the terrible conditions of her own African advocates, men and women, who have to fight and vanquish all stereotypes. Ms. Bauer's presentation of her evidence of the public protector's spend on legal fees could have been done differently without putting us under this. Chair, there is so much we can say about this, and I'm here representing myself and the Four Silks, all of us and the juniors who can't come here because they've been presented out there yet again as people whose services are of no value, and they were picked because they are supposed to be black and corrupt. From our vantage point, it is hard not to conclude that this is what she intended. Her cruelty and hatred of us as her colleagues should not find space in this august house. Our own fights as colleagues should not come here. Chair, as I said, eventually, because the media space was fertile, is always fertile to perpetuate anti-black narratives. Our names were hardly off the screen, and we were splashed in the Daily Maverick as RET tricksters and foes of the Constitution. Again, this is an inevitable result of the reckless handling of potentially ruinous evidence by Ms. Bauer. Chair, because I will give you the entire statement that we have, I want to end by saying this. This apparent ineptitude in her handling of evidence last Wednesday or Thursday suggests lack of experience, maybe, but I wouldn't go there. I think it suggests disrespect for this house. And we want to say to you, although she has corrected this, for the future, we think our names were used in vain and she has caused great pain. And we do not expect this parliament of our people to be used to perpetuate pains we've gone through for generations. And we ask that this committee notes this. The whole statement in a written form, Chair, is here, and I will send it to you. But lastly, Chair, I want to raise this again to the members. We are very sorry that we came this way. We're very sorry, Chair, that I know you for a long time personally, and I respect you. It was because of the gravity of the situation, and we did not know if we approached you outside this process, whether we would not compromise you. It's only for that reason. It was not a hijack. Thank you, Chair.
Thank you, Advocate Senior Counsel Skakane. You've excellently exhausted that 10 minutes in what you've just made. Yes.
I just wanted to say Advocate Masugu SC would have been here with us as well. She's one of the Four Silks that had thought they should come here because they could handle this for our black juniors who can't. Thank you.
Okay. Thank you, Senior Counsel Skakane. I suspect, therefore, Senior Counsel Ngalwana, he also spoke on your behalf. Unless you want to just say something?
Thank you, Chair. I have nothing to add.
Thank you. Thank you, Senior Counsel Ngalwana. I had directed that the matter be registered. It will not be for discussion. We take note of what you have presented. We are going to await, as I indicated, the formal written concerns being placed, including that statement. I need to immediately say that having listened to you in accepting this, and we certainly as a committee, as we approach the deliberations, are going to get into all of this. Members are still going to be asking questions after the cross-examination. And so you registering the point is not going to get lost. There will be that opportunity. There will also be an opportunity for the deliberations into this. But I do want to say as a chair, so that it's important that that point is registered. It's registered not to take away anything in terms of the content you've placed in front of this committee. That this committee had designated as a pioneering process what we call a hybrid process of members of the committee leading the charge, but with the external expertise in the form of evidence leaders. And for that, the work they do is not to be confined to Advocate Mayosi and Advocate Bauer. They do work on behalf of the committee. I would fail in my duty, therefore, not to make that point and properly defend Advocate Bauer, that this is not Advocate Bauer's issue, that Advocate Bauer is placing on record, as she would have done from day one of witnesses, evidence that she thinks that the committee must know, hear, deliberate on. And it is this committee that is going to determine whether the kind of evidence put in front of it is going to assist it in terms of the two possible outcomes that we have. The two possible outcomes, the first outcome is that this committee will conclude and say, Advocate Mkhwebane is fit to hold office, and that she would have come in front and exonerated herself. That's the first possible outcome. The second one is that this committee might make findings for her not being fit to hold office. There is no middle wish. This process is not going to end in the middle with neither of these. And we've been very mindful about that, that this is what we need to do. So I do want to make the point so that, and I can see Advocate Skakane, the issues come a long way, so that we do not become a collateral damage as the inquiry in terms of the historical issues that in a very short space you wanted to place, and hopefully when we give you that proper opportunity, things will be kind of ventilated further. But I really wanted to make that point. I can sense how you feel, but I think it's proper that as the committee, we place that on record, that there would be no issues as a chair. Yes, I'm a chair of this committee. There are no Advocate Bauer issues as leading evidence together with Advocate Mayosi. So those are the matters that we're going to deal with. That's the first point I wanted to make, and thanking you for presenting your points. I would insist that we respect and are open, and they're going to be more coming even as because even in the nature of the report we're going to do, it's going to be such a transparent process. We're going to do a report and ask everybody else to say, what do you think about this report, including the public protector. So we will remain that transparent, but as you would also know that there are limitations in everything else that we do, as enshrined in the Constitution. So thank you very much for what you have presented. We will certainly take note and engage with it ourselves as members of this committee. And as I ask members, we're not going to engage with that presentation, so that I do not keep you any longer, having registered the point. But Themba Nkosi Ngoma is the committee secretary, because what we have done now is not complete. There's a follow-up that needs to be made so that things are properly on record. So I want to thank you. Thank you very much.
Thank you, Chair. May we be excused? I've been accused of walking out before, so I want to just check. Thank you.
And here you'll be accused.
Well, Advocate Skakane, we saw you walking out, yes. As we saw Advocate both walking out, so you are excused officially, formally.
Can I accompany him even though I'm on virtual? Can I accompany Advocate Skakane, please?
And they don't need to be accompanied. Thank you very much, Advocate Skakane. Advocate. Oh, sorry, Advocate Bao. Sorry, just before
you want to say this in after they've left. So can I just have an opportunity to say this? I don't want to delay the process by having a tit for tat and responding, but I will reserve my rights to the extent.
It's only fair that I hear that.
Okay, Chair, I'm not stopping you, but you said you are going to recognize me, but that's fine.
But that has not changed.
Okay, thank you, Chair.
Advocate Bauer.
Sorry, Chair. I don't want to delay the process for committee reasons today, but I do reserve my rights in respect of what has been said today.
Thank you, Advocate Bauer. Advocate Skakane and Advocate Ngalwana, you are excused. Thank you. Advocate Mbofu.
No, thank you, Chair. I also don't want to delay you further, but just wanted to point something out. Firstly, thank you, Chair, for making that indulgence. As I say, I'm now speaking in my capacity as one of the people on behalf of whom they were speaking. But back to my current head, I just wanted to say that if you allow me, Chair, to explain because there's some issue here about not setting a precedent and all that. And to say why I made the request in the form that I made, I won't motivate. I'm just going to read section 59 of the Constitution. It says the National Assembly must facilitate public involvement in the legislative and other processes of the Assembly and its committees, including this one. And B, conduct its business in an open manner and hold its sittings and those of its committees in public, but reasonable measures may be taken to regulate public access, including access of the media to the Assembly and its committees, to provide for the searching of any person and where appropriate, the refusal, entry, or the removal of any person. 2, the National Assembly may not exclude the public, including the media, from a sitting of a committee unless it is reasonable and justifiable to do so in an open and democratic society. That's all I want to say. Thank you, Chair.
Thank you, Advocate Mpofu. What you have just pointed out is very correct. That's also our understanding. But that section of the Constitution would not deal with the procedures of how that is made possible, because you then have to have procedures and arrangements.
Yeah,
to enable
but the Constitution is supreme to those so-called procedures.
Yeah, so there would be rules and regulations to allow for to effect that spirit. Thank you for that. Just before I go back to you, Advocate Mpofu, for the cross-examination, I just want to indicate to Mr. Cornelius van der Merwe that you please unmute.
Yes, sir.
That you remain under oath, and I will quickly ask Advocate Bauer, as she requested, to complete placing that matter on record with you. Advocate Bauer.
Chair, I'm now in your hands, because for me to correct the errors that we had made on the numbers requires me to deal. So can I just check with Advocate Mpofu? Are you going to legal fees today? Maybe you and I can have a chat over the lunch adjournment.
No, actually, that's a good question. No, I'm going to leave that area. Well, not the numbers, but I'm going to deal with it broadly.
Okay. So
if we're not schedules.
If we're not,
sorry, Chair.
if we're not dealing with the numbers today, can we agree that we defer this until we have a conversation?
A discussion, okay.
Okay. Chair, then there's only one aspect that I need to deal with, Advocate van der Merwe, under understanding that I may need to come back to the corrected numbers with Advocate Mpofu's consent. And this goes to the document that we put up. It's the extended NVM 14, the revised reporting data. If you could just put that on the screen in the Dropbox. And Mr. van der Merwe, if you recall, we had taken you through the schedule reflecting the amount of new cases, total cases, etc., and the number of reports that the public protector had completed for the period in question. Do you recall that?
That's correct, Chair.
There was a second table on the page that, again, because of us making the numbers bigger for purposes of sight, didn't show up, and I completely forgot to take you to that table. Just give me a second. We seem to have.
Okay.
Mr. van der Merwe, before we put it on the screen, can you just explain, when we talk about formal reports, what the difference is between that and the actual number of complaints lodged?
Yes, formal reports is or are reports that are issued in terms of section 181(2), 1A, B and C. It's report with a finding and a remedial action. It also includes what we call closing reports that are signed off by the public protector as final reports. And these days it also includes what we call advisory reports that Advocate Mkhwebane has also started in her tenure. So it's all reports signed off by the public protector.
Right. And you had previously testified that this doesn't include provincial reports that are issued that are not signed off by the public protector, correct?
Provisional report.
Provincial.
Yes. Closing reports. Yes, closing reports are signed off on executive management and management level. Yes.
Right. So, and it is the reports that form the subject matter of court applications.
Yes, the majority of, sometimes it would be like in Jim's case about jurisdiction, but most of the review applications is for the judicial review of formal reports, yes.
Right. Maybe if you can make the second table bigger. Can you explain this to the committee? Advocate van der Merwe.
Yes. Yes, thank you, Chair. These are, if you just go to the dates first on the left-hand side. These are the number of what we call formal reports that have been issued by the Public Protector Advocate Mkhwebane. You'll see that 2016-17, we've got a total of 17 actually on the total right-down corner, because 7 was still issued in the tenure of Advocate Madam
Mr. van der Merwe, Mr. Van der Merwe, we're going to have a long day. I'm going to ask you that you reposition yourself so that we can properly hear you. You're fading and your voice is very low, so we're not able to catch everything you say.
Apologies for that. I'll be closer to the mic. I'm as close as possible.
That's much better.
Yes, I apologize in advance for the being so close to the screen. If we can go back to the screen, I'll also try and speak up. This represents the total number of formal reports issued by the Public Protector for the last 6 years. The first batch is split between Advocate Mkhwebane and Advocate Madonsela.
Sorry, Advocate van der Merwe, can I just interrupt you there? Just for clarity, that's because it's midway through the process that Advocate Mkhwebane comes into office, correct?
That's correct, in October 2016. And these reports reflect the reports released in financial years. So from the 1st of April until the 31st of March. So there will be an overlapping period of approximately 6 months. The reports reflect for 2016-17, 10 formal reports were issued by Advocate Mkhwebane, 17-18, 34, 18-19, 46, 19-20, 137, 20-21, 73, 21-22, 112, and we do not have the figures yet for this year as we are in the midst of the year. Of those formal reports, then on the right, the next column C is the number of closing reports. Of the total number of reports, it's not additional, it's how many of those reports were closing reports. It's 2 for 2017, 18, 18, 19, 6, 21 for 19, 20, 21 is 24, and 21, 22 is 23. Then column D is the number of reports from those years that have been reviewed and set aside on judicial review. It's 3 for the 2016-17 year, 5 for 17-18, 8 for 18-19, 12 for 19-20, 3 for 2021, and 3 for 21-22, and 2 so far for 22-23. And then 1 report, closing report, have been set aside, but that's also the subject of a rescission application that is in 21-22. Then column F is the number of pending reviews that were posed at the time. Some of them have been reconsidered, but in total it is 24. Then we also have 23 unopposed judicial reviews that are of the reports that have been released in those years, were the subject or are the subject of those reviews. It is dealt with in more detail in the column, in the schedule dealing with the judgments and judicial reviews. Thank you, Chair.
So this was the position at the time we had prepared this table, and although the position with reviews pending and opposed and unopposed have changed since then, we will, if the committee requests, provide an update if that's required. But I just want to put into context that this was the schedule at the time we prepared this in this financial year. So all the data up until March 2022 would be would remain unchanged. There may very well have been more reports reviewed and set aside since we had looked at this data. Is that correct, Advocate van Merwe?
Yes, that's correct, Chair.
Thank you, Chair, and thank you to both Advocate Mpofu and yourself for the indulgence. I just forgotten to do this last time.
Thank you, Advocate Bauer, for placing those matters in the manner you did. Colleagues, just to make sure we manage the processes properly, I'm going to ask that we take an LET for 15 minutes so that we don't interrupt once the cross-examination starts, so that it's able to flow from that point to lunchtime. So we'll take a 15 minutes break and back at 25 to 12, and then we resume the cross-examination. Thank you, colleagues.
Recording
We'll take a
stopped.
tea break.